Well, I told everyone I would see you tomorrow, but tomorrow is tomorrow and I'm back today. So we're going to get into it and talk about what just happened today, March 5th, 2026. All right, this is absolutely massive. And I know a lot of people here don't like magazine bans. And apparently, DC doesn't like magazine ban either because in DC, they just ruled that magazine bans are unconstitutional and magazines are protected by the Second Amendment. Now, this is for the District of Columbia Court of Appeals, which is different from the United States Circuit Court of Appeals for the District of Columbia. This deals with a guy named Tyree Benson versus the United States. He appealed to the Court of Appeals after being convicted. So let's go ahead and talk about what Tyree Benson, I'm just going to call him Benson, I keep on calling him Tyrese for some reason, Benson was convicted of. He was convicted of possession of a large capacity magazine. This is section 102506.10 of the DC's criminal justice statute, and this is a law preventing magazines holding more than 10 rounds. He was also convicted of possession of an unregistered firearm, which is 7250201 Section A, and carrying a pistol without a license, violation of 224504 Section A, and unlawful possession of ammunition. 7250601 Section A, subsection 3. So he challenged these convictions, arguing that DC's magazine ban of holding more than 10 rounds violates the Second Amendment. He also raised, but he did not reach, a challenge of the DC's registration scheme and everything else. And also, he had a couple Fourth Amendment arguments. But that isn't what we're here to talk about. What we're here to talk about is the core issue, which is DC's ban on large capacity magazines. I consider these standard capacity magazines, but according to DC, any magazine holding more than 10 rounds is considered a large capacity magazine. The court held that it is unconstitutional to ban those magazines, and they used a couple different cases to determine that. The first case is District of Columbia versus Heller, which deals with our friend Dick Heller. They also reference New York Pistol Rifle Association versus Bruin, which has been a big part of Second Amendment law because Bruin said you can't use intermediate scrutiny. It means in scrutiny is another word for it to determine if a law is constitutional. According to Bruin, you have to look at the plain text of the Constitution. Benson is a member of the people, so that is not in doubt. And the question is magazines protected arms? If magazines are considered protected arms, then his conduct is presumptively constitutional. Now, a bunch of states have tried to argue that they're nothing but accessories and they are not protected arms, but this court did not buy that and stated that his right to carry a magazine is presumptively constitutional and that it would be up to the state to prove with with tradition and history of firearms regulations that the law is constitutional. DC did not carry that burden. And the final case was referenced was Rahimi, the United States versus Rahimi, which was argued in 2024. The majority held that the magazine ban violates the Second Amendment. 11-round magazines qualify as arms as protecting as protected by the Second Amendment because they are integral to the function of semi-automatic firearms, especially for self-defense. Now, the whole self-defense thing, I think, It should be for any lawful purpose. But a lot of states try to put in the self defense thing. But the court said even if that's the case, a lot of people use magazines holding more than 10 rounds for self defense. In fact, if you look at a Glock 19, they hold 15 rounds. A Glock 17 holds 17 rounds, and those are two of the most popular handguns in the world. Plus AR-15s, they all hold 30 rounds. They also ruled that such magazines, such as those holding more than 10 rounds, are in common use. And since they are in common use, you cannot ban them. And Heller said arms that are in common use are protected, which means you cannot ban them. So the DC Court of Appeals said because these are in common use, they cannot be banned. Now, there is no historical tradition of banning commonly bearable arms like these. That's what the court said. There is a how and why that they can get into. The DC try to use Bowie knives, for example. Hold on. I got a Bowie knife right here, in fact. They try to use Bowie knives here, bans on Bowie knives, which they weren't actually banned. There's just, you couldn't use them for crimes. And gunpowder limits. Gunpowder limits, the court actually said, you can't use those because gunpowder limits was gunpowder within a city because they were a fire hazard and had nothing to do with the Second Amendment. They banned only having a certain amount of gunpowder in your house because it would burn down the whole city. So that was blatant. That was rejected by the courts because that's the way it is. So the court invalidated the ban facially. That is important. Why is that important? Because it's not as applied. They didn't invalidate the plan as applied to Benson. What kind of weird commercials is that? It mutes John and play weird. I have no idea. YouTube is doing some weird stuff. But since it's facially, it knocks it down totally. It knocks it down. So it's just not for one person, it's for everyone. Okay. So because of the unconstitutional magazine ban made registration, licensing, and lawful ammunition possession impossible for the firearms using such magazines, which all the ones that Benson was using, it made all of other charges be reversed because they said you can't register a magazine, and since that magazine is unconstitutional to ban that magazine, you can't charge him for the other crimes. So basically all his crimes are reversed. Every single one of them was reversed and vacated. But since they did that, the court said we don't really have to touch the registration and licensing scheme as a Second Amendment claim or your Fourth Amendment challenges because we're knocking it down before we get to that stage. There was one dissent, and the dissent was from Chief Judge Blackburn Rigsby, who did dissent and argued that the ban should be upheld because she disagreed with the common use test because she said, we had to apply Bruin. We didn't apply Bruin the right way with common use. And also that courts elsewhere has held up similar bans, which whatever. And also she stated that 30-round magazines are not common in common use, which is absolutely ridiculous because they are. I got like 1,000 of them over there. And she says the ban should have survived both a facial and as applied challenge, but it wasn't. This is a win for everyone out there. It's not a circuit split. You got to remember, this is the District of Columbia Court of Appeals, not the United States Court of Appeals for the District of Columbia Circuit, for the DC Circuit. So this is basically equivalent to a state level court. So it's not applied anywhere outside DC, but it's applied to DC, which helps me out because now I can go into DC with my 15 round mags. So this is a big deal if you live in DC or you live in the DC area and you travel to DC. So this is a court fighting with the Constitution saying it's unconstitutional to ban large capacity magazines. And it's a good thing, not only for the people of DC, but it shows that we can get wins in places where you wouldn't think we would get wins. The DC court system is very left leaning, and yet we had some judges that said, hey, we we agree with this and it should be knocked down. So, yeah. Also, it shows you the shifting of the courts as well because the judges were the ones that decided is a Trump appointees. So there you go. All right. That is it. Let me get out of here. Thank you so much for watching, and we are happy that we got this win, and hopefully more wins will come. Thank you so much for watching, and I will see you tomorrow, maybe.